difference between written work, contract work, and litigation. In the recent past, I've represented a client selling a piece of property, and there was an issue, the city of New York saying that there needed to be a new water meter. So when you're the seller's attorney, you have to order a final water meter reading, and we determine what amount is past due, if any, or what amount is actually due. And why is that? Because water, they bill you in arrears. So if you're closing in March, you'd have to pay water for January, February, and March. And quarterly, the city bills you. So it's always paying for a past usage. Now, that wasn't the case here, that my client owed prior money, but a final water bill would also show prior money, like the quarter before. If a person had been late or wasn't paying timely or didn't have money, sometimes that does happen, right? Person is selling a property, they receive a bill, they think or understand they're going to go to closing relatively quickly, and they say, I'll pay at the closing. And before you know it, the closing doesn't take place. Second water bill comes, and right, it's like a metronome. It comes every 3 months in New York City. So while we were waiting, we weren't waiting in this case, we ordered a final water meter reading, and the city came up with this story that my client needed a new water bill. So we were wrestling. Did we do it? Did we get it? Should we get it? Are we required to get it? Should we give a credit? And my client hired a master plumber to put it in. And the city wanted to make sure that the pipes weren't lead. It's a real debacle. So now we have money held in escrow. We did put in a new water meter reading, and we did we did put in a new water meter. We did get a reading. We didn't get the item called final water meter reading, and money was held. Buyer is saying that they have to put in yet another new water meter. Doesn't seem to make sense. And they have to put in new pipes. We're debating it. This is the contract. There's an escrow being held, and now we're going to go to litigation over this issue. At least litigation is threatened. We're still trying to resolve it. And I'm going to make up a number. Let's say $10,000 was held. It's a different amount. The seller, I represent the seller. The buyer wants to take all $10,000. We don't want to give the buyer that because it's not appropriate. We're willing to give the buyer some small sum of money, let's say $1,000 for aggravation, perhaps, that they had to go through. We did what we needed to do. So now we're wrestling over the $10,000. And the number is different, but that's kind of the circumstances. Should you just split the baby with the bathwater, like not Herod, that's a different king. Solomon split the baby. If it was $10,000 in escrow, should we give up $5,000 and have my client take $5,000? Well, that's a considered choice. And we'd have to look at what the cost of litigation will be and what would happen as a result of litigation. I always propose settlement where appropriate, and in that hypothetical, fictional example of holding $10,000, well, litigation does cost more than $5,000. So maybe it would be in my client's best interest to settle for that. We're going to look into it and discuss it and problem solve and solutionize it. Solutionize.